so and so, come to paragraph 2. That I am a law intern under Firdos Samim and Gopa Biswas. Both are advocate, usually practice at Calcutta High Court and having chamber at 10 Kiran Shankar Rai Road, opposite side, Civil Court, so and so, Calcutta. I have witnessed a serious, contemptuous and disturbing incident in and around High Court, Calcutta and its surrounding areas. Therefore, I am giving this information and I being an informant making this affidavit for the necessary and appropriate actions and or steps against the said persons. Right. Therefore, she was informing an information, and that was a basis of initiating or whatever it may be said that contempt. My point is, the Honorable Chief Justice had no independent information, but information was based on this. The question which I am framing or submitting, if the Honorable Chief Justice has no independent information and initiate a contempt proceeding on the basis of the information in the shape of affidavit of petition has been given to the Honorable Chief Justice, can it be a suo motu contempt proceeding? Yes. But my submission would be here that in a case of suo motu contempt proceeding by the Honorable Chief Justice, Chief Justice will have an independent information not based on any information supplied by any of the parties. And your lordships in your lordships order have indicated these are the petitioners. And they are contesting the matter. They are contesting the matter. Now, since I have since I am reading this affidavit, let me read this. That on 24th April 2025 at around 4 p.m., a group of individuals started causing unrest in and around High Court, Calcutta, and in front of 6 old posters blocking the main road and entrance of the High Court, Calcutta, so and so. Thereafter, mob went to a large number of persons started using filthy languages against Honorable Justice Vishwajit Basu, and by showing Honorable Justice Vishwajit Basu photograph, they targeted Honorable Justice by using filthy language and create en bloc. Thereafter, even targeted advocate also. Targeted advocate also. My submission would be, so far the honorable judges are concerned, if it has been done, of course, it's a contempt. But so far the advocates are concerned, it's not a contempt. There may be a criminality may be there. That's a different thing. That's a different thing. I saw this physically as well as various social media platforms and news portal platforms. They just pause for a moment here. Recently, although it's not a final judgment, very recently, 5 or 7 days before, Supreme Court was taking a matter that was of the Gujarat High Court, where the ED has summoned, etc., called him, etc. Before that, the Mr. Arvind Datar. Then the Justice Vishwanathan has made an observation. Of course, advocates are the integral part of the justice, but that's not a final decision. Integral part of the justice. That I am not disputing the contention that advocates are the integral part of the justice delivery system. But point is here, if there is, let's assume that for the moment all the charges are correct, So far the advocates are concerned, whether it would be criminal contempt. So far the honorable judge is concerned, yes. Next is Millet. They wrongfully restrained the learned advocates and other persons associated with them from entering into the chambers and also going out from their respective chambers of the said building. These persons had also wrongfully confined some lady advocates in their respective chambers and also compelled some of the lady advocates to stay outside their chambers. And so they were constantly making provocative and derogative statements against the present sitting judge of the Honorable High Court at Calcutta and against the judiciary. They are also threatening to cause given injury. They are also hurling abuse of lady advocates with an intention so and so the jury to this thereby done a criminal content. Some of the aforesaid persons causing such unrest have been identified as Raju Das, Jamal Sheikh, Devajan Nath, Abdul Halim, Atanu Rai, Sukumar Raut, Rajesh Shankachar, Taposya Swayansu, Lakshminath Tudu, Shivanth Kulti, Supriyo Noskar, and others. Stop. Here, your lordships will not find that my client's name is there. Then, that the unruly group of individuals started threatening using slang languages and even started shouting that they will brutally assault each and every one involved against their case. There is huge threat on security of the advocates. They did not spare the Honorable Justice Vishwanath Basu, who is hearing the case, the Vishwajit Basu. They directly threat that they will transfer the case from that court, so and so, I am not reading. Even had pictures of Honorable Justice Vishwajit Basu, Calcutta High Court, and some advocates. They placed those pictures on the main road in front of 10 kilometers, starting those pictures with their feet and spitting on them while making videos of it. Surprisingly, Kolkata police officers were just standing by a distance watching the whole scenario. The above mentioned persons, along with others hooligans, also scandalizes and or tends to scandalize and also lowers and or tends to lower the authority of the honorable court, thus involve themselves to a criminal contempt. That the other mentioned persons, along with the other hooligans, tries to prejudice and interferes or tends to interfere with the due course of judicial proceedings. Said persons also interferes or tends to interfere with or obstruction, tend to obstruct the administrative justice and so. They failed to show respect towards the Honorable Sitting Judge of Calcutta High Court and also towards the judiciary. That around 8 p.m., Mr. Bikash Ranjan Bhattacharya, senior advocate, after getting the news of the incident, compelled to come evacuate his junior members safely. And soon as he arrived, the group of people started shouting, provocating, derogating, contemptuous, and defamatory action and statement and proceeded as a mob towards him with an intention to assault and hurt him. Mr. Bhattacharya and also intends to assault and hurt him. There is no complaint from Mr. Vikas Ranjan Bhattacharya to that effect to the police. And not a single advocate has, I have not seen that any single advocate has made any complaint to the police. And Mr. Bhattacharya's senior advocate just called the junior members from the chamber and tried to rescue them safely so that they can return back to their home. When all of them, cause suddenly the unruly mob started to assault them and we were also manhandled. We were also manhandled. Therefore, they are parties to the matter. Advocates' name, excepting Vikas Bhattacharya, names have not been stated. It is partly mentioned that the place of the said instance is very close to the premises of the Honorable High Court at Calcutta, and the said place of the Honorable High Court at Calcutta is high security. Is therefore indeed alarming to note that the manner in which the unlawful assembly complex so and so, Kiran Shankar Raido, and causing unlawful, chaotic, and unruly disturbance of public disorder more than four hours while making scurrilous, contemptuous, and defamatory remarks against Honorable City of Calcutta and other learned advocates, including senior designated advocates of this Honorable High Court at Calcutta. This unlawful incident could seriously brings down the dignity of the judiciary, which should strictly to looked into. That after that, one Kunal Ghosh, spokespersons of ruling party of the West Bengal, organized a press conference with above mentioned persons, and try to prejudice and or interfere or tends to interfere with the due course of judicial proceeding. said Kunal Ghosh also tends to interfere with the administration of justice and also tends to obstruct the administration of justice in several months. He has failed to show respect towards the Honorable Sitting Justice of Calcutta High Court and also towards of the judiciary. This unlawful conduct seriously brings down the dignity of the judiciary, which should seriously be looked into the involved themselves to a criminal photocopy of some of the newspapers. Then it is expected that persons claiming themselves to be educated and responsible persons would bring faith and allegiance to the Constitution of India and maintain so and similar leave aside. 8. That the above mentioned persons along with the other persons leave aside. 9. That I therefore most humbly praise that your lordships may graciously please to take cognizance regarding the actions. That is a prayer. And statements made by the above named persons, including Kunal Ghosh, so and so, towards an initiate suo motu contempt proceedings, so and so. Now, therefore, if we just see the incidents, they have not said at the time of the occurrence of the incident, Kunal Ghosh was present. According to them, after the incident has happened, Kunal Ghosh made a press conference. And these persons were along with them in the press conference. My lord, there is no statement that the Kunal Ghosh, why at the time of press conference, let's take it. I will deal with my affidavit. I will say that what statements have been made by Kunal Ghosh which constitutes contempt. Kunal Ghosh was not present at the time of incident. Kunal Ghosh did not pass any remark against the justice. Neither whatever has been said that the Kunal Ghosh was involved there. Whether holding a press conference along with the, let's take it for the timing argument's sake, that they have the contempt, they have committed a contempt. Whether if I hold a press conference about anything, not hitting the judiciary, should be contempt, criminal contempt. This is similar to the affidavit. Therefore, we from the affidavit, these are the law students. They are interned under whom they have not said Firdos Samim and Gopa Vishwas. They have not said anywhere in the affidavit, excepting the name of Bikash Bhattaji, who are the advocates. The large number of advocates, large etc. There is not a single document which can show that the incident was reported to the police. My submission would be, my lord, let's take it this incident itself. Whatever the allegations have been made is correct, excepting Justice Basu's portion. That maybe they may attract the my lord, any of the provisions of the Indian that is now BNS. Now, in this matter, my lord, with no complaint is there. There may be other matters. I am not appearing in other matters, but I am saying in this matters there is no complaint. No, and no complaint that the Kunal Ghosh was directly involved in that incident. Now, my lord, next is, my lord, I kindly come to page 9. These are, my lord, the newspapers reports. My lord, my lord, I do not think that I would require to cite any judgment to the holding the proposition. The newspaper reports are not an evidence. It has no evidence. If they take, even I will say submit that if they want to rely upon them, they should have called for them the writers, authors, and the editors as witness, so that I would have got the chance to cross-examine them. What is written and what is not written. There is no prayer. Next, these are the photographs have been given. What are the evidentiary values of this photograph? What is the certificate? Even take it Miller old Evidence Act 65B or etc. have not been complied with. Section 65B. My submission would be before a lot to be in short. It's a quasi-criminal trial. And rigors of criminal law have to be fulfilled. Although it's a summary proceeding, but in a case of a criminal contempt, which is a quasi-criminal trial, it cannot be. If they rely upon, they have to bring witnesses. They have not brought it. They have not made any application. And what is there? Let's read it. Even assuming that's not. Let me, for argument's sake, that is assuming that it's an evidentiary value. What is there? চাকরি প্রার্থীদের নিয়ে সাংবাদিক বৈঠক কুণাল ঘোষ সরাসরি সংবাদ প্রতিদিন ডিজিটাল। What the content? If today, if someone has committed crime and if they stand near to me and while holding my press conference, that means I am also party of that criminal proceeding. Now, these are the pictures. Here in these pictures, even is not very legible. Nothing cannot be identified. And Kunal Ghosh picture is there. It is not there. Now, kindly now you take since I am reading the affidavit, let me complete this part. Kindly take the affidavit of Kunal Ghosh. My another submission, kindly note that although it's an affidavit, there is a prayer, it is the nature of an application. Can just kindly excuse me. Although it is in the name of an affidavit, it is really an application for drawing up contempt proceeding. This affidavit. And all throughout, my lords have, before we came into the picture in the orders itself, your lordships have described them as petitioners and us as a contemptors. Now, kindly take the affidavit of Kunal Ghosh's affidavit. কোনটাতে কেন
কত রে অ্যাফার্মেশন 11th জুন
June. Can I read below? Can I please? I am the alleged contender number 8 in the instant contempt petition. I am fully aware of the facts and circumstances of the instant case. I am competent to sign and affirm this one. I have been served with a copy of the criminal contempt petition being shared so and so, along with criminal contempt petition being so and so, purportedly affirmed by one Tiyasha Guho, one Amitabh Ghosh anyway, and one Tapos Maiti, respectively, thereafter as also. Direction passed by the Honorable and however, upon going through the aforementioned contempt petition, it can be discerned that I was not made a party to CLLSP C number 5 of 2005 and CLB number 6. I have only been arranged as alleged container number 8 in CRLP number 7 of 2025. At the outset, I tender my unconditional and unqualified apology for any inadvertent act of mine which may be perceived to lower the majesty, sanity, and authority of this honorable court. I have immense respect and full faith in the judiciary, and I do not have any ill intention to lower the sanity and majesty of this honorable court. I respectfully submit that I hold this honorable court in the highest regard and esteem, and I will always ensure to make all possible efforts to comply with any direction which will be passed by this honorable court in the letter and spirit. Before answering the rule issued upon me on its merit, the following submissions are necessary to be made on the maintainability of the instant contempt. It is submitted that Contempt of Courts Act is an act enacted by the Parliament with the purpose of defining the processes to answer. Section 2C, Roman 2, kindly leave aside. This is a rule. Section 50 of the list, kindly leave it. Now, Roman 4. From perusal of the records of the present case, which have been served upon me pursuant to the order passed by the Honorable Court, the three affidavits filed by the complainants and the order passed in connection with instant criminal contempt, it cannot be discerned that the complaints sought for the consent of the learned, it cannot be discerned the consent of the learned Advocate General before filing the contempt application. Thus, it appears that the motion has not been made with the consent of the learned Advocate General. Although the solemn order dated 2nd May 2025 passed in connection with the instant contempt case records that the instant proceeding for criminal contempts have been initiated suo motu by the court of the Honorable the Chief Justice, no such orders passed by the Honorable Chief Justice has either been served upon the deponents or is available to the in the public domain on the website of this Honorable. Furthermore, it is also not known to me that apart from the three affidavits, what other materials were available before this Honorable Chief Justice for initiating the suo motu contempt proceeding against me. From the affidavits and orders served upon me, it is apparent that the suo motu contempt proceedings were initiated by the Honorable Chief Justice primarily on the basis of the three affidavits filed before the Honorable Chief Justice. Thus, the basis of the instant criminal contempt is the affidavit filed by the private person without the consent in writing of the learned Advocate General. It is submitted that the written consent of the learned Advocate General is not a mere formality and has a salutary purpose. And since learned Advocate General is the highest law officer in the state of West Bengal and is vitally interested in the purity of the administration of justice and preserving the dignity of the courts, learned Advocate General is expected to examine whether the amendments in the proposed motion of criminal contempt are made vindicating public interest, general power and accord to their declined consent postulates to the said provision. If any motion of criminal contempt in the High Court is not accompanied by the written consent of the learned Advocate General, the very purpose of the requirement of prior consent will be frustrated. Thus, for a valid motion with strict compliance with the requirement of Section 15 of the Act is mandatory. A motion under Section 15 not in conformity of the provisions of Section it is not maintainable. It is submitted that since the suo motu contempt proceedings were not done in terms of Section 15 of the Contempt of Courts Act, neither or in terms of the well-settled principle for initiating of the present suo motu contempt proceedings are not maintainable. It is stated that by the solemn order of 2nd May, this Honorable Court was pleased to direct that all concerned would be at liberty to file affidavits to bring on record any relevant material in compliance with such a direction. The affidavit in reply was prepared by me, but the same could not be finalized in the absence of the report of the Commissioner of Police that was directed to be filed in the Honorable Court. I was advised by the learned advocate to reply upon the police report for the factual events which led to the initiation of the instant criminal proceeding. However, since my learned advocate on record received the said police report only on 18 May night of so and so, even through email, I could not finalize and file the affidavit in compliance with the directions enshrined in the solemn order and sent due to the delay in receipt of the police report. Kindly pause for a moment, Milord, that before issuance of the rule, your lordships were In your lordship's order has written that the no affidavits are filed. That is the reason for this expense. Thereafter, the contempt application was এটাই তো হুম thereafter uh, this says that this says the honorable court was pleased to direct sorry. Thereafter, all contempt application was sent not was not taken up for the consent of 19 May to the by the honorable larger bench of this court, comprising of the lordship, the honorable justice Ojit Banerjee, so and so. On 19 May 2025, this honorable court was pleased to issue a rule against which it said rule is meterable. I have received a copy of the rule issued upon me by this. I have gone through the rule and understood the meaning and purport thereof. The rule records that I was part of the unlawful assembly on 25th April 2025 at 10 Kiran Shankar Rai. However, this allegation is not correct as I was not present at the 10 Kiran Shankar Rai Road, Kolkata 7 lakh 1 and 25th on 25th April 2000. The instant affidavit is being filed by me in response to the rule issued by this Honorable Court. I humbly seek the leave of this Honorable Court to file additional affidavit in this regard, if so required or directed by this Honorable Court during the course of hearing of the instant matter. Before dealing with the parawise allegation and averments made and or contained in the affidavit filed by the complainant in connection with the instant criminal, I say as follows. At the outset, it is stated that I was not present in the 10 Kiran Shankar Rai Road or in the vicinity of the Honorable High Court at Calcutta on 25th April 2025. I have no relation whatsoever with the protest at 10 Kiran Shankar Rai Road on 25th April 2025. This report filed by the Commissioner of Police confirms this statement of mine. Thus, the impeding me in the petition is unwarranted, as I had no, and I have never instigated anyone. Sorry, I had, as I had no. No connection whatsoever with the protest in question. I have been implicated in the instant contempt proceeding for oblique motives. The complainants in their affidavits have prayed for initiation of for the incident which took place on 25th April 2025 for 4 p.m. to 9 p.m. at 10 kilo so and so. The cause title of the affidavit prays for initiation of contempt proceeding for obstruction of justice, interview of advocates, scandal of the court, and interview with the so and so was not. It is reiterated that I was not present with the other alleged contemners on the said date and time and date so and so. I am a law-abiding citizen of the country, and I harbor deepest respect towards the judiciary of our country. I have never made any willful attempt or malign or scandalous the judiciary of the country. It is stated that I am an ardent well-wisher of the candidates who are not getting employment in school despite being otherwise eligible for the same, and I wholeheartedly wish that the eligible and honest candidate secure their deserving employment. However, I have always advised these candidates to repose their faith and trust in the judiciary, and I have never instigated anyone to commit any illegal and under the garb of protest. Some of the candidates, including alleged contender number 1 to 7, approached me on 26th April 2025 with their grievances that a group of learned advocates, including Mr. So represented them before the Honorable Court in W and W. The candidate further informed me that two applications being so were filed and moved by the learned advocate Mr. Firdos Sami for addition of some of the candidates who are supporting the prayers of the aforesaid two representatives. The petitioner so primarily prayed for a direction to appoint them as assistant teachers in physical education and work education for publication of the interview list containing the details of all the candidates in strict compliance with rules so and so. It is a direct